training program. CUTS Institute for Regulation and Competition was founded in 2008 by Pradeep Mehta with the mission to be a center of excellence on regulatory and competition issues. CIRC is uniquely positioned in providing capacity building program, research, advisory, and advocacy, primarily focused on economic regulation and competition policy and law and infrastructure sectors with an objective of reaching out to the target audience in India and other developing countries in Asia and Africa. Since its inception, CIRC has been taking several training programs, seminars, and public lectures on competition policy and law in India and abroad, and offers online courses as well. The Institute has also made cerebral contribution in the work of High-Level Committee on National Competition Policy. A sister organization, Consumer Unity and Trust Society, known as CUTS International, established in 1983, has built up a formidable reputation as a leading research, advocacy, and networking group engaged on issues of international trade and development, competition, investment, economic regulation, human development, and consumer protection. It has 6 overseas centers in Geneva, Vietnam, Washington, D.C., and 3 in Africa. It is accredited to many intergovernmental and multilateral bodies such as WTO, UNCTAD, UNDP, World Bank, Asian Development Bank, etc. Winter School is a flagship event of CIRC organized annually. In collaboration with globally renowned organizations, CIRC has organized 5 editions of Winter School in the past in India in a physical setting, but in these unprecedented times of
Hi,
COVID,
baby is speaking.
I'm sorry.
We'll request everyone to put or the administration should put it on mute for everyone.
But in these unprecedented times of COVID-19 pandemic, we have taken it to a virtual mode, and in a way, it has been a blessing in disguise as this has enabled us to bring in more global experts in the field of competition law as well as participants. This course is especially designed to enhance the understanding, application, and appreciation of the interconnection between economics and competition law. The knowledge acquired through this winter school will be relevant regardless of the jurisdiction in which you work. Case studies, decisions, and approaches from the US, EU, and developing countries will be discussed within a common analytical framework strongly based on economic theory. Now I would like to invite Dr. Arvind Mayaram, Chairman of CIRC, for a formal welcome address. Dr. Mayaram is an Indian Administrative Service Officer of 1978 batch belonging to Rajasthan cadre. He's a former Finance Secretary of India. Presently, he is also serving as an economic advisor to the government of Rajasthan. Dr. Mayaram, over to you.
Thank you very much. Cataclysmic events disturb equilibrium and result of change. Sometimes the changes are permanent in nature and lead to a new equilibrium. COVID-19 has changed the world in many ways, including the way competition is understood in terms of economic development. The COVID crisis has brought forth a new perspective to the global supply chains, which suffered heavily due to nationwide lockdowns all over the world. As some essential industries like pharmaceutical production are completely outsourced by various jurisdictions, the governments wanted to move towards independence from interdependence, and several rules were changed to accommodate this. For instance, there is a major shift in the attitude of the competition authorities towards cooperation between the firms. There were sudden price spikes for essential commodities as the markets failed to meet the demand instantaneously of the new essential commodities like masks, sanitizers, and even, it appears, toilet paper. Price gauging due to inefficient allocation of resources became a major issue. Therefore, while it was strictly prohibited before the COVID crisis, the authorities, while recognizing the need for certain level of cooperation between the firms and are now concerned with differentiating between the positive firm cooperation and the negative firm cooperation. Exponential growth in digital economy also has been a game changer. Digital economy, which was ready on the rise even before the COVID crisis, grew by leaps and bounds this year. There was already a big debate going on how to effectively regulate the digital landscape, which is so prone to tipping. This has taken on great urgency now. US with its Senate hearings of the big tech companies and the European Union with its Digital Act package are taking a lead on this front, but all the competition authorities need to put in place effective policies and legislations to protect the interests of the consumers in the long run. Several industries like food, healthcare, and retail, which were heavily under stress during this period, and as a result, concentration in these markets have happened by vertical and horizontal consolidation. Smaller players and new entries in the market need protection from going bankrupt or being acquired. This would continue to be an area of serious concern for some time to come. Keeping in mind the whirlwind of changes that have taken place this year, it is imperative to reintroduce ourselves to economics of competition law in a completely new paradigm. Exchanging thoughts and ideas with people involved at various levels of competition enforcement from diverse jurisdictions is going to be highly valuable and beneficial, which this platform seeks to provide. We have a very high powered panel of speakers consisting of globally eminent speakers. I'm confident that the participants of the Winter School from across the world will immensely benefit from the experience and the depth of knowledge of the speakers during this week long series of interactions. I welcome all the speakers and the participants to the Winter School. Thank you.
Thank you, Dr. Myram, for your words. Indeed, there is now an urgency to revisit competition enforcement in the wake of COVID-19 pandemic, as well as the expedited digital transition. And this winter school will help the budding competition practitioners build a strong foundation in this area. Now I would like to invite Pradeep Mehta to give a keynote speech, although there's no need to introduce him in the competition world, but for the benefit of all, I'd like to mention Pradeep Mehta is the founder and Secretary General of CUTS International and founder and treasurer of CIRC. Among several advisory positions, he has been or is honorary advisor to the Commerce and Industry Ministers of India, Trade, Commerce and Industry Minister of Zambia, and to the Director General of the WTO. Under his vision and guidance, CUTS and CIRC have done tremendous work in the field of competition and consumer protection. Over to you, Mr. Mehta.
Thank you, Garima, and thank you, Arvind, for inviting me to speak at this particular event, which is something which we had, as was pointed out by Garima, the Institute was established with the purpose of strengthening knowledge, strengthening capacity, and enhancing knowledge. And so what we are doing in this particular event is to enhance knowledge as well as strengthen capacity. And personally, I'm also thankful to the excellent faculty who have agreed to teach. Fortunately, being virtual, it is not so difficult now as compared to what used to happen in the past because of travel schedules, etc., etc. These are the sort of upsides of virtual interaction, as it were. Now, Arvind has spoken about various dimensions of competition policy, and particularly in the modern era of both. I mean, let me just flag two dimensions of what he spoke about, and which is so important for us to understand. One is COVID-19, and the other, of course, is digital economy. Now, both are things which are totally new in our world. Not that digital economy is as new as COVID-19, but the fact is that all of them have their own of economic governance, competition policy, as well as our own, the various laws and regulations that exist to govern them. For example, when we talk in terms of COVID-19 and competition, uh, this is something which I'm sure you'll hear Frederick Jenny speak about in a more lucid manner than I could. But recent discussions I've had is that how do competition authorities deal with the kind of situation which emerges as a result of economic downturn? Many countries are facing very bad times, including India. Secondly, another aspect which has cropped up in our discussion on COVID-19 is the availability of medical medicines and medical devices, vaccines, etc., without the sort of the hanging rope, as it were, of the intellectual property rights which have emerged from the WTO agreement signed by governments in 1984 and came into being. Now, these are issues which are still being debated, and we hope that as we roll out in future, that economic sense will prevail upon policymakers to ensure that this happens. Now, in terms of digital economy, there are many things which are still beyond our comprehension, as it were. Algorithms are something. And one classic case which has been discussed quite often is when algorithms are colluding. Is it a human intervention? It is not a human intervention. It's a mechanical, it's kind of an intervention done by two robots, as it were. How do you deal with that? But that, again, I leave it to our faculty to speak about. Now, let me go back into the history of competition law and policy around the world as to why it came about, why was it necessary to do so, and what is the kind of historical background to it. Even in a country like India, in the year 300 before Common Era, or what is also used to be called BC, Chanakya, the famous economist, the famous political economist, spoke about cartels. Now, every other law which evolved dealt with cartels in one manner or the other, etc. And there's a very famous expression of Adam Smith, who said that when people of the same trade get together, they just don't get together to make merry, but also to talk about how they could best exploit the market in their favor. Whether they are buyers or they are sellers, both. Now, secondly, what was also argued, and this issue came up at the WTO, the World Trade Organization, that it should look, the World Trade Agreement should also cover competition policy, among other new policies, investment policy, etc., etc. Fred Jenny chaired the working group on trade and competition policy. The point there was that there are so many international trade practices which impact competition. And can we have an international or multilateral understanding on it, and so on? That did not work out for various political reasons rather than economic reasons. But the fact remains that in spite of those discussions at the WTO, large number of countries were drafting new competition laws. At the time of 1985, about 35 countries had a competition law. Today, the number is about 150 and expanding and increasing, including the former communist countries, current communist countries, fragile economies. I mean, everywhere possible, people are talking about having a competition law. It is no longer a rich country luxury. That is what an argument was made at one point of time, that this is not required for developing countries. We are able to manage our markets in the best manner possible. Now, some of the main purposes of a good competition policy and law is to provide the safety nets or the regulatory safety nets, and also to promote economic democracy or industrial democracy, as it's also said. If you look at the history of competition law, it is widely understood that the US was the first country in the world to draft and adopt a competition law. On the contrary, it was Canada which drafted the first law in 1889, and the US drafted its or adopted its law, competition law in 1890. Except that the vigorous competition of the US competition law, what is also called antitrust law, is what people then imagine that US is the first country in the world. Now, interestingly, both the US laws and the Canadian competition laws were as a consequence of agrarian unrest. Demands made by agriculturists that they could not sell their produce in the market except through these combines, or that is how the word antitrust came, because in the US these combines or cartels were called trusts. But I mean, one can always think that why antitrust is such an oxymoron. Yeah, that is how the word antitrust came in. Now, if you go down further, I mean, in some other countries, for example, in Finland, there was a typical case, again, agrarian interest. Timber producers were being sort of boxed in by the timber processors. And the matter went up to a court there. Excuse me, I just said the right reference. In 1837, the timber processing mill owners colluded to dictate prices and quantities to forest producers. 1837, the court struck it down, but the result of that was that the debate remained dormant till 1948, until it was raised with renewed vigor. This catalyzed the formation of a committee which led to the first competition law in Finland in 1958. In France, the initial foundations of a competition law were laid by the Chapelier Law of 1791, which contained a provision that barred members of the same trade to assemble for the purpose of promoting their common interests. This could mean either purchasing from basic producers or selling to customers. The 1810 Penal Code prohibited any concerted act to manipulate prices that could distort free competition. After tracing the history of the evolution of competition policy and law, it becomes equally important to understand why countries adopt competition laws. And there's a paper that I've written along with another friend, a common friend, Simon Evanet, which has been circulated to all the participants, which I recommend to you highly. Sometimes laws provide for the competition authorities right and responsibility to intervene in other government policies, which promote anti-competitive outcomes. Now, these are usually other policies which do not violate the competition law as such, but violate competition principles. In some, there are explicit provisions in some laws. There are explicit provisions granting the power of intervention to the authority, while in others it is through advocacy provisions where the authority can submit opinions to the government. And usually a right-thinking government would adopt them, would agree to them, unless there is a strong counter-argument that such an anti-competitive provision should exist for a wider public interest. And these are exceptions which can also be made. Now, when we talk in terms of particularly this kind of issue has become very important in former communist countries, particularly USSR and Eastern Europe, etc., where there were a large number of enterprises in the state sector, and which did not, which had never sort of been subjected to competition of any sort, and they had to then face a very typical problem. Even in a country like Holland, and this is not a former communist country, till 1975, cartels were not prohibited. And they were treated as orderly market arrangements, that flower sellers and so on and so forth would sit together in their chamber, a guild or a chamber or an association of producers, and decide what the prices were, etc. In Malaysia, when the competition law came in after much effort, as recently as 10 years ago, the first action they took again was against an association of florists, flower sellers, who never thought that what they were doing were wrong, but except that they were making it easy for the customer to know that, look, these are the prices which are fair, quote unquote, and therefore we are not colluding, we are not doing anything which is anti-competitive. Now let me go to the larger question of how competition laws started in the world and how does it relate to what happened in the past. Quite often, competition laws were price control laws, whether it was Norway or Kenya or India or Pakistan and many other such countries, including Britain, where price capping was considered to be an important anti-competitive tool to regulate prices. Now, what happened was that not only that, but even size. The India's MRTP Act of 1969 even regulated the size of an enterprise, or the number of goods that they could produce of a type which they were licensed to do. For example, they were allowed to produce 10,000 widgets. They would be penalized if they produced a 10,001 widget, for example. So there was, I mean, this is all command and control economy, as well as the good old ideas about maintaining a regulated market, as it were, rather than a competitive market, without understanding that competitive markets can do better for the economy as well as for the customers and consumers. So there was a whole shift in thinking across the world that big is no longer bad, but the abuse of bigness is bad. Which is, dominance is not bad, but the abuse of dominance is bad, which you hear as we go along this course. Now, how do you determine many of these issues? Earlier, what prevailed was the rule of law, very black and white, per se rules, etc., etc. But gradually, all competition legislation shifted. And many countries, including India, adopted a second competition law, where it shifted from rule of law to rule of reason. And the big was no longer bad, but it was abuse which was bad. Now, how do you determine many of these issues? Many of these issues for which you require economic analysis. And not just a legal analysis. It's not a simple issue about comma and full stop or semicolon that you could determine whether there was a violation or not. But to go into it in an in-depth manner. And I'm glad that Fred Jenny would be taking the first class where he could postulate these issues more clearly and more vividly than I could. Therefore, I think it is important for me to conclude here and to request you again to participate in this course actively and to the best extent possible. And at the same time, also do reading as far as possible to see as to how we can all together make the world a better place to live in. Thank you. Garima? Over. Thank you. Am I in time?
Yes. Thank you, Mr. Mehta, for sharing your wisdom and enlightening everyone with the evolution of competition law. This winter school is a 6-day training program from today, that is 14th till 19th of December, wherein we have 8 speakers. Today's session is on Economics of Competition Law by Frederick Jenny, Chairman, OECD Competition Committee. On the 15th, the session is on Horizontal Agreement by Dr. Rhonda Smith, Senior Lecturer, University of Melbourne, and former Commissioner, Australian Competition and Consumer Commission. I was notified this morning that Dr. Alan Fels, former chairman ACCC, will not be able to co-present with Dr. Smith now, as he's just had an unexpected operation and is advised bed rest. 16 December is Vertical Agreements by Payal Malik, Advisor Economics and Head Economics Division, Competition Commission of India. 17 December is Abusive Dominance by Dr. Geeta Gauri, former member Competition Commission of India, Dr. Gauri is also recovering from COVID and is not in a position to deliver a long lecture. So Neha Malhotra and myself will be co-presenting with Dr. Gauri. 18 December is merger control by Anna Barker, competition expert OECD. And 19 December, which is the last day, is intellectual property and competition by Shubha Ghosh, Crandall Melvin, professor of law, director, Syracuse University, College of Law, New York. Please note that the timings of the session will vary some days as we have speakers from different time zones. If due to your time zone or any other reason, you're not able to attend the live class, you can access the recordings later. You will have a temporary access to all the recordings until 15 January. The presentations will also be circulated after each session. I would like to thank our Chief Operating Officer, Nidhi Maheshwari, for her support in organizing this event, my colleague Bhavi Agarwal for her assistance in coordination, Amit Kumar for the IT arrangements, and our remaining office staff for their support. If you have any queries or concerns during the winter school, please do not hesitate to reach out to me or my colleague Bhavi. Thank you all for participating in our training program. We hope that this training is insightful and enjoyable to you all. Now let's do a quick round of introduction of all the participants. I would call out your names one by one. Please introduce yourself with your profession and affiliation. First is Carlos Enrique Moro Mamani. Carlos. All right, moving next, Shreya Singh.
Hi, can you hear me?
Yes, we can hear, but we can't see clearly.
Hi, everybody. I'm a Peruvian lawyer. I work in the copy. I like to increase my knowledge about the economics of competition law, and I am excited to participate in the course.
Thank you, Carlo. Shreya Singh.
Hi, everybody. This is Shreya Singh from AZBN Partners India. I'm really happy to be part of this group and looking forward to learning a lot in the next few days.
Thank you. Mohit Gauri.
Hi, I'm Mohit. I also work at AZBN Partners India and happy to be here.
Thank you. Varun Thakur.
Hi, I'm Varun Thakur and I also work at AZBN Partners and equally excited to be a part of this and to gain some insights for the next few days.
Thank you. Mel Marquez.
Greetings, everyone. I'm a lawyer, an academic. I'm based in Melbourne. It's good to see everyone. Look forward to learning something about economics, and I look forward to the week's events.
Thank you. Nikita Mayers.
Hi guys, I'm Nikita Mayers from the Barbados Fair Trading Commission. I'm the current acting chief economist, and I look forward to a very insightful session this week. Thank you.
Thank you. Anthony Topman. Anthony Topman. Troy Waterman.
Hi, Troy Waterman here, Acting Director, Barbados Fair Trading Commission. Looking forward to the sessions.
Thank you. Sharvina Bhugun.
Hi, I'm Sharvina Bhugun. Can you hear me? Hello? Can you hear me?
You're audible, Sharvina.
I'm the legal secretary at the Competition Commission of Mauritius. Thank you.
Thank you. Rivashini. Rivashini Parshuraman.
You have to unmute yourself.
Sorry. Hi, everybody. I'm Rivashni Paraswaman from the Mergers and Acquisition Department of the Competition Commission of Mauritius. Thank you.
Thank you. Yanis Girasu.
Hello, I'm a legal research officer of the Competition. Thank you.
Siddhant Khitawat. Satvik Mohanty. Parth Sehan.
Hi everybody, I'm Parth. I work with CIRC Associates and I'm really looking forward to this session this coming week. Thank you.
Thank you. Nripi Jolly.
Hello.
You're audible.
Hello. Okay. Hi, good afternoon, everyone. This is Nripi this side from Jyoti Sagar Associates. I'm looking forward to a wonderful learning experience in the near future.
Thank you. Aditi Khanna.
Hi, I'm Aditi Khanna. I'm also with JSA, Delhi, India, and I'm looking forward to this week's session.
Thank you. Priyanshi.
Good afternoon, everyone. Am I audible?
Yes.
My name is Priyanshi, and I am pursuing LLM, my master's degree in competition law from Jindal Global Law School. Really looking forward to this session and the insights. Thank you.
Thank you. Shane Nichols.
Hi, good morning, everybody. I'm Shane Nichols from the Barbados Fair Trading Commission. I'm really looking forward to the session.
Thank you. Utsav Soraut. Utsav Soraut. Shahbaz Khan.
Hi, this is Shahbaz from Center for Development of Telematics. Government of India.
Thank you. Juan Pablo Lara.
Hi, everybody. My name is Juan Pablo Lara. I work as a lawyer in Costa Rica. I'm very excited about this week's sessions. Thank you.
Thank you. Ravi Shyam Madira.
Hi, I am Ravi. I am from Jubilant Biosis, Bangalore. I'm the Director, IPR and Legal Department. Thank you.
Thank you. Abhishek Nair.
Yeah. Hello, am I audible?
Yes.
Yeah. Hi, everyone. My name is Abhishek Nair. I'm a fourth-year law student from GGS IPO. I'm looking really forward to learn the economics of competition law.
Thank you. Ushasi Das.
Hi, I'm Ushoshi Das. I work with the Corporate Legal Department of ITC Limited, and I'm joining in from Calcutta. I'm very excited to be here. Thank you.
Thank you. Rohan Chusiwala.
Hi, I am Rohan. I am part of the legal team at Jubilant Life Sciences Limited.
Thank you. Deepti Jethli. Ajay Kumar.
Hi all, I'm Ajay Kumar from Jubilant Life Sciences Limited, looking after compliance. Looking forward for an enriching session here. Thank you.
Thank you. Leonard Otunye.
Leonard, you have to unmute yourself.
Oh yeah, I'm sorry about that. Okay. Yeah, my name is Leonard. I'm a lawyer based in Nigeria. I work on trade and competitiveness in Nigeria. I work for the Center for Trade and Business Environment Advocacy and also as the representative of CUTS International in Nigeria. I look forward to the week of learning. Thank you.
Thank you. Shubhangi Heda.
Hello.
I'm Assistant Policy Analyst at CUTS International, and I'm looking forward to the sessions. Thank you.
Thank you. Ujjwal Kumar.
Hi, I'm Ujjwal Kumar and working as policy analyst with CUTS International. I'm also a lawyer by training and look forward to learn some economics to enrich my learning into the competition law implementation aspects. Thank you.
Thank you. Paridhi Galundia.
Hello everyone, I am a fourth year law student at the Institute of Law, Nirma University, and I'm looking forward to all the lectures. Thank you.
Supriya Julka.
Hello everyone, I'm a fourth year law student from Institute of Law, Nirma University, and I'm really excited for this 1 week winter school. Looking forward to learn with you all. Thank you.
Thank you to all. Now we begin our first session. Our first session is on Economics of Competition Law by Dr. Frederick Jenny. He's a professor of economics at ESSEC Business School in Paris. He's a chairman of OECD Competition Committee since 1994 and co-director of the European Center for Law and Economics of ESSEC. He was previously non-executive director of the Office of Fair Trading in the United Kingdom, judge on the French Supreme Court from 2004 to August 2012, vice chair of the French Competition Authority 1993 to 2004, and president of the WTO Working Group on Trade and Competition 1997 to 2004. Professor Jenny holds a PhD in economics from Harvard University, a doctorate in economics from University of Paris, and an MBA degree from ESSEC Business School. We are honored to have you here today, Dr. Jenny. I would like to make a few house announcements. It's a virtual classroom, so we'd request you to keep your videos on while attending the session so our speakers can see and interact with you all. Your audios will, however, be kept muted unless you have a question for which you'll be required to raise hand first. There's a 15-minute halftime break after 2 hours of the session. I'd request you all to be back in time to the session. We have assigned last 15 minutes of the session. Actually, Dr. Jenny prefers question answers throughout the session, so you can ask questions anytime by raising hand. I hope you enjoy the session. Dr. Jenny, over to you.